Hey there, it's Seb Fry here with another exciting episode of It's a Seb Show. And today I want to talk about canceling a non-contingent contract, which is a very interesting concept because, non-contingent contracts, they're not meant to be canceled, right? I mean, when you make a non-contingent offer on a property, you're saying, hey, no matter what, I'm buying your property. Except, well, here's the except if I do, that means that I may be held liable for up to 3% of the purchase price as liquidated damages, right? So when you make an offer on a property, you are supposed to put some money into escrow, right? Could be $1,000, could be 10%, could be anywhere between there, right? But typically you'll find that realtors want to see 3% of the purchase price as the earnest money deposit, because that is the maximum that the seller may be able to collect from the buyer in the event of buyer breach of contract, right? And I say maybe because, if you put your money into escrow and you have a non-contingent contract, or you've released all your contingencies and you cancel the contract, that money does not automatically go to the seller. And if you think about it for a second, if it did automatically go to the seller, why would you even need escrow anyway, right? You wouldn't. You would just write a check to the seller and say, there you go, there's 3%. You keep it no matter what. No, it doesn't work like that. You put your money into escrow. And if you cancel the contract, in order for the seller to get that money, even though per the contract, the seller may be eligible to keep up to 3% of the purchase price as liquidated damages, maybe, right? You have to sign another piece of paper saying, okay, seller, here you go. You have my earnest money deposit, right? It's called an escrow instructions because no money leaves escrow without buyer and seller signing the instructions, agreeing that that's where the money is going to go. So the buyer, in many cases, is not automatically going to agree to give the money to the seller. You're just not going to do it, right? Because a lot of the times the buyer may feel that, the seller made a misrepresentation about the property, or some unforeseen event occurred, which the buyer feels means that he, can't or shouldn't have to complete the sale. Who really knows, right? Things happen. Non-contingent contracts can get canceled, and they do get canceled. Okay, less frequently than, contracts that have contingencies, granted, but a non-contingent contract can get canceled. So what happens to that money? So if the buyer refuses to sign a piece of paper saying, hey, seller, you go ahead, you keep that money, what happens? Well, here's an interesting thing. Escrow companies, they will not keep a deposit from two different buyers, right? They won't have two buyers making a deposit on the same property. They just won't do that, right? So if a seller wants to sell the property and that money is still in escrow because a former buyer and the seller are tussling over who gets that money, the seller will be unable to accept a new deposit from a new buyer unless the seller moves that to a new escrow company. And a lot of sellers aren't going to want to do that, right? Also, when you make a purchase offer, when the seller agrees to sign a purchase offer, they're basically saying they're not already in contract to sell the property to somebody else, right? So if the seller has not signed the cancellation contract saying where the money is going to go to, the seller is technically still in contract with another buyer, and he can't sign a new contract while somebody else still has that uncanceled contract in effect, right? So there goes two reasons why a seller can't sell their property, until the disposition of the earnest money deposit has been determined. And the other reason why, at the end of the day, let's just say that the seller, he goes ahead and gets a new escrow company and is working on getting a new buyer together. All the buyer has to do is tell the seller, hey, guess what? I'm going to sue you. I'm going to sue you over this earnest money deposit unless you give it back to me. And then that puts the seller in a very hard position, because if the buyer does actually go and file a lawsuit against the seller, that becomes what's called a lis pendes, right? A pending lawsuit against the property, which is also a cloud on title. So if there's a cloud on title, guess what? No lender is going to loan on that property while there is a cloud on title. And in fact, even if it's a cash buyer, how many cash buyers are going to want to proceed to purchase a property which is involved in a lawsuit? The answer is not very many of them, right? So now here's another question that happens sometimes. Is, let's just say you want to cancel the contract before you have even put your money into escrow. What happens then? A lot of people think that if you haven't put your money into escrow, then you're not going to owe that deposit. That is false. You can still get sued or whatever, or action can be taken against you for breach of contract, and they can try to get your deposit as liquidated damages even if you haven't made that deposit. Even if you made 1% or 2%, they can still try to get the full 3% from you. And if you've made no deposit, they can still try to get that full 3% from you. So just not putting your money into escrow does not, insulate you from the risk that the seller could go after you for that deposit. Now, let's say you cancel your non-contingent contract, and whether or not your money is in escrow already, the seller is upset, right? And they're rattling their saber, right? They're getting all huffy, and they're saying, hey, I'm investigating my legal options to see what I can do to you. Well, if that happens, my advice is to immediately contact a lawyer, right? Or at least line a lawyer up and get ready to be able to respond to any, legal letter that you may get from the seller. That's the number one thing you should do. And speaking of lawyers, by the way, I'm not a lawyer, okay? I'm a real estate agent, right? So like all of this is just sort of like in the field, in the trenches, kind of experience that's hard earned over, more than 18 years in the business, right? So, I'm not a lawyer, and definitely if you're in a situation like this, you should talk to a lawyer, right? But if the seller does do that and is saying like, hey, you're going to owe me this money, you should know that there is probably a way out of that contract, and it's probably totally legal and probably pretty easy to do. And that's because, you see, when you are buying some real estate, most sellers will have to provide you with a transfer disclosure statement. Some sellers are exempt, like if it's an estate sale, or if it's like a corporate sale, a bank-owned company, a bank-owned property or whatever. So there are some exemptions for providing a TDS form to the buyer. But for most buyers, you will get a transfer disclosure statement, which is a form which is mandated by California Civil Code. And the California Civil Code says the buyer must have a chance to review this document prior to close of escrow. It doesn't say when prior to close of escrow, but just prior to close of escrow, at some point before escrow closes. The buyer must have at least 3 days to review that form if it's delivered in person, or 5 days to review the form if it is delivered not in person, which would mean, I guess, these days electronically via email or downloaded from a website or something like that, right? Okay, so the buyer has that time to review the transfer disclosure statement. Normally, when you're making a non-contingent offer, you are going to be getting the transfer disclosure statement like days before you ever make your offer, and you'll have time to review it. But let's just say you want to get out of your non-contingent contract. The first place you're going to want to go is you're going to want to look and re-examine that transfer disclosure statement to make sure that it is filled out in full. A lot of times, sellers miss some information on that form, right? They just don't check the right box, or they leave something blank when they should have left it blank, or they make a material misrepresentation on that form. It happens quite a bit. So just go through the TDS and make sure that it is filled out. If they're missing any information, guess what? The seller has to resubmit a TDS form to you, which gives you 3 days to review if that form is delivered in person, or 5 days to review it if it's delivered electronically or some other way, and you're not satisfied with whatever change, and it's not open to interpretation, right? It's like you can approve or not approve. You don't got to explain any changes made to the TDS form. And so that is a huge way out. Now, here's another way you can possibly get out of that thing, is that a lot of times, as I said, they have misrepresentations, right? For example, on the TDS form, there's a question: have any repairs or whatever, or improvements or modifications been done to the property without necessary permit? I'll tell you what, it is amazing how many times sellers just say, no repairs requiring permits have been done without permit, right? Well, the question isn't whether you, the seller, have made any such repairs, is are you aware of any such repairs ever having been made, right? And a lot of times, you'll actually see this in the MLS. It'll say like, third bedroom added without permit, or garage converted to living space without permit, or something like that. They'll just say it right there very nakedly. But on the form, they'll say no. And maybe they're mistakenly thinking that, oh, well, I didn't do it. I bought it that way. But yet you knew about it because it says right there in the MLS, private remarks that this was done without a permit, right? So like, if you can find anywhere where the seller has misstated any material fact on the TDS, and I'll tell you what, it really isn't that hard to actually find such mistakes. Guess what? The seller is then going to have to correct that form and send it over to you for your review. And guess what? If you don't like anything put on there, well, you have 3 days if delivered in person, or 5 days if it's delivered any other way, to review the changes to the TDS. And if you don't accept them, guess what? You can cancel the contract. It says that right in California Civil Code. So, there are a number of ways to get out of that. One new and exciting way to get out of a contract is that there's a fire hardening disclosure and advisory. I forget what it's called, but basically any house which is in a high fire or very high fire hazard zone is supposed to provide this form to the buyer, telling them that the house is in a high or very high fire hazard area. Well, guess what? This form is pretty new. And this actually came into effect, I believe, July 1st of this year is when the first time it's actually required to be used. A lot of people aren't actually even filling in this form, right? So that form hasn't been provided to you, and a TDS is required by law, and it's in a high or very high fire hazard area, for example. Guess what? You can cancel the contract just because they didn't include that form. So you want to take a look at those disclosures, the TDS in particular, and make sure that the property is as it was represented to you in disclosures, and that's the basis on which you made your non-contingent offer. And if you find that there are mistakes or omissions, that right there is a really good way to place where you want to be. So before you do put in a non-contingent offer, you really want to make sure that you are very, very comfortable with everything having to do with a property, especially these days, insurability, because that's becoming a real issue. A lot of buyers are getting bitten by these really high insurance premiums now. So you just want to make sure that you are certain that you know everything there is to know about the property, and you are committed to seeing the sale through come hell or high water. But just know that if something happens and you feel you need to cancel the contract, that you are not automatically going to lose your deposit. And I have to say, in all my 18 plus years of doing this, I have seen scant instances when anybody ever lost some or all of their deposit. And I can say that no buyer I've ever worked with has ever lost their deposit. Now, I haven't actually been in a situation very often where buyers have made non-contingent offers or released their contingencies and then canceled. But I have seen it a few times where I represented the buyers, and it's uncomfortable, it's stressful, it's harrowing. But at the end of the day, everyone just walked away, not exactly as friends, but not getting sued, and that's a very good thing. Listen, that's all I have to say right now about canceling a non-contingent contract. But would you do me a favor? Give me a comment. I would love a comment. Like if you have any input into this, any insight, any experience with this, I would love it if you could write a comment right here. That would be awesome. Or if you like what I'm saying, if you're digging it, give me a thumbs up. I would really appreciate that. And this would be fabulous if you would share this with somebody that you know who is making a non-contingent offer or having to cancel a non-contingent contract, or if you're a seller and you're looking at non-contingent offers, just share this with somebody who might be in that situation. And this, let me tell you folks, this would be the bomb. If you would go ahead and click that subscribe button right there on my YouTube channel and subscribe to my channel on YouTube, I would so appreciate it. All right, well, that is it. That's all I got for this episode of It's a Seb Show. But don't worry, hey, it's okay. I'll have another episode up again before too long.